Good morning to each of you. Today's date is February 1st, and we're scheduled to hear the second of our oral arguments this morning, and that would be the case number 21CA0044-M, Turner versus Ormandy. I'm Judge Theodosia. I'll be presiding over the arguments today. With me, as you can see, are my colleagues, Judge Carr and Judge Callahan. Each of you will have 15 minutes to present your argument. The appellant may reserve up to 5 minutes for rebuttal. If you're going to reserve time, let me know, because I'll be keeping track, and I'll let you know as you get close to that time. As you both know, the argument is being visually and audibly recorded and live streaming on the court's YouTube channel. So we always ask that if you're not arguing, that you put yourself on mute. That minimizes distractions in the background. The judges in this case, I can assure you, have read the briefs and we're prepared to proceed. So appellant, would you like to reserve any time?
Yes, Your Honor. I would like to reserve 5 minutes for rebuttal, if it may please the court.
Very good. I'll let you know when you're getting close to the 10-minute mark then. Are you all set to argue?
Yes, Your Honor, I am.
All right, you may proceed then.
If it may please the court, I'm John Oberholzer. I'm here on behalf of the defendant in this case, John Ormandy, who was the defendant in an eviction case that was filed in the Medina Municipal Court. And then because of a counterclaim exceeding the jurisdiction of the municipal court, it came before the magistrate of the Common Pleas Court of Medina County, Judge Kimbler's courtroom. Magistrate held a hearing, took evidence, made a decision that indicated that John Ormandy was not entitled to possession and he should be evicted. This, of course, was then appealed to the Common Pleas Court. Judge Kimbler, who wrote an opinion, again, is indicating that in the opinion that John Ormandy was not entitled to possession. And in the process, the appellants had raised an argument that there were not all of the parties before the court that had an interest in the eviction, and argued under rule, I believe it's 19A2, that there were other parties that should be in this proceeding who were not. That was really disregarded. And then, of course, after the decision of Judge Kimbler, this matter came up on appeal before this court. In our argument, we would like to call the court's attention to 4 major facts. First of all, there is no lease here. This is all oral. Secondly, this is a case, it's not about whether there's a subtenant, tenants, whatever. It's a case about possession. Does the plaintiff have the rights to possession against the parties who are in fact in possession? No question but what not only was John Ormandy in possession, but also a corporation, Elyria Arts, and a museum, the Medina Train and Railroad Museum. Third, this is a case where the rent was being paid. The only question here was the landlord felt the rent was not enough. I think the evidence is very clear that the landlord at least believed the rent was not enough. And as a result of that, exercise their rights that they have as a landlord to terminate the tenancy. And then last, and perhaps maybe the most important fact is a notice, a 3-day notice to evict was in fact served on John Ormandy. It said DBA, but it did name the other 2 entities that had possession of the property. And why you would put them on the notice to evict and not name them as parties has always been somewhat of an interesting issue here. But the fact is, under Rule 19A2, the Railroad Museum and Elyria Arts were parties that needed to be brought in as part of this eviction. So the question of possession could be determined among the 3 parties that should have been served. Our legal argument is really quite simple. Number one, the rule says that Elyria Arts and the Medina Train and Railroad Museum should have been joined as parties. They were not. And as a result, the decision was not correct. As I've indicated, the notice of eviction named these two entities. The court, the Common Pleas Court, wrote a very good opinion, but we would argue did not really address possession. It's concerned about whether or not there are rights of tenants. Interestingly enough, I like to comment on this. The court cites a case from 1940. I find that interesting for a couple perspectives. A, it was done under the old rules of civil procedure, and I must confess that Chancery Court and those things are a little foreign even to me. But the point of that case is that there was no subtenancy created, and it was on a written lease. There's no lease here, and we feel that's significant. And we would argue that the court was concerned about rights of tenancy as to whether or not you were a subtenant or not. We would argue that's not the question. The question in an eviction case is possession. And in order to determine possession, you need to involve all of the parties that do have possession. My last argument, yes.
Counsel, I have a question for you. You started, and I don't think there's any dispute here, you started with saying that there's no dispute that rent was always paid, correct?
That's correct.
How does that take that out of a tenancy evaluation then into a possession evaluation?
Well, I think whether you're a tenant or not, if you have possession, you need to be served with a lawsuit dispossessing you of possession. Just because you may not have rights as a subtenant, you still have possession. So I'm arguing the issue here is, do you have, I mean, nobody's arguing they shouldn't have been there. They were there. The only question the court gets hung up is, and what's their status? I'm saying the issue is, do you have a right to be there? That's why the lawsuit was brought. My last legal argument has to do with this evidence that the plaintiff felt compelled to bring in that talked about whether that, I guess, went to the argument of whether or not this rent was reasonable. And I objected to a lot of this evidence. I think it was unnecessary, irrelevant, and shouldn't have been brought in. The magistrate let it in anyway. And the question I guess the court needs to decide, how far does this get to go? I mean, you litigated the personal lives of these people, I think ad infinitum. And I think that was error, should not have been allowed. And I think the court should reverse this matter because the improper parties were not improper, but the proper parties were not all before the court. I've reserved a few minutes for rebuttal. Yes.
Can I ask you a question on that last issue? For the sake of my question, let's assume that what you say on that evidence being improper and going too far is correct. How did that affect this decision-making process regarding possession?
Well, I don't know. I mean, you can't get yourself in the mind of the triers of the facts. It's to me, a lot of it was just plain scurrilous. I mean, why do you have to introduce evidence about the fact that he got her a wedding dress or something? I mean, I just think that's that goes too far. And how do you know what the effect on the trier is? I would say it shouldn't even be there, and then you know it has no effect. And if it did have an effect, we would argue it's wrong. Thank you.
Thank you.
Any questions, Judge Carr?
No, thank you.
All right, thank you very much for your argument. You'll have your full 5 minutes, by the way.
Thank you.
For rebuttal. All right, council, 15 minutes. You're muted, by the way.
There we go. Can you hear me?
All right. Yes,
Okay,
now we
great.
can hear you.
Great, thank you. May it please the court, my name is Michael Larrabee and I represent the appellee Cynthia Turner. And it's our position that the trial court properly ruled that the summons and complaint in this matter were subject to the trial court's jurisdiction, that Mr. Ormandy was subject to the proceedings in enforcement, entry, and detainer, and that it properly granted Mrs. Turner the possession of the property on her first cause of action. Mr. Ormandy's arguments involve the weight and the sufficiency of the evidence presented at the trial court level. And the appellate court must affirm that decision unless it finds as a matter of law that it's not supported by preponderance of reliable, probative, and substantial evidence. The appeals court would apply an abuse of discretion evaluation here and determine whether the trial court clearly lost its way and created a manifest miscarriage of justice. This Ninth District Court of Appeals has always stated that it's mindful of the presumption of the in favor of the trial court's factual findings, and the trier of fact is in the best position to determine the credibility of witnesses and evaluate the testimony.
But counsel, that assumes that all the proper parties were named, right?
Understood, yes. Mr. Ormandy's, basically his three issues are essentially the same, that Elyria Arts Inc. and the Medina Toy and Train Museum, an Ohio nonprofit, are actual tenants, and that Mrs. Turner failed to name these entities on the eviction notice and the complaint. But all of the evidence presented at the trial court level is contrary to that position. If you look at the transcript, Mr. Ormandy himself testified at trial that he began renting the retail space in 1991, him individually, and he was the tenant from the very beginning. In the early 2000s, Mr. Ormandy expanded his toy and train store to occupy the entire first floor. And in the mid 2000s, he took over the upstairs space to use as a train museum. And he testified at trial that he took over all of these spaces as John Ormandy individually. And he concedes that there's no written lease agreement between Mrs. Turner and Elyria Arts Inc. or the nonprofit, the Train Museum, as tenants. Mr. Ormandy's own witness, his name was William Nels. He was a board member of the nonprofit. He testified at court that he never saw a written lease agreement between Mrs. Turner and the Train Museum. And he testified that he would give money to Mr. Ormandy on behalf of the Train Museum, but he never tendered any checks to Mrs. Turner directly. So Mr. Ormandy concedes that there's no signage on the building which identifies this entity, Elyria Arts Inc., as a tenant, and there's no signage that identifies the Train Museum as the nonprofit entity as a tenant. But it's our position that in an attempt to derail or delay this eviction, he argues that he started using the corporation Elyria Arts Inc. to operate his Train Museum approximately 8 years ago. And Elyria Arts Inc. was a picture framing company that he bought out of Elyria, Ohio, and he moved that to Wellington, Ohio. And he's the president of that corporation. His position is that he decided about 8 years ago that Elyria Arts Inc. was now the tenant of the property without even notifying Mrs. Turner. And it was somehow her responsibility to find out that he made that distinction in his internal records. There was an exchange on the record between Mr. Ormandy and the magistrate, which really shows the motive for this was purely for tax purposes. He indicated that Elyria Arts Inc. had a number of losses that he wanted to write off. So he decided that he would instead use the toy store as the tenant and write off the losses of the Elyria Arts Inc. entity against the profits of the toy company, the toy store. The other issue is that he personally deposited the monthly rent directly into Mrs. Turner's account for nearly 30 years. He didn't send checks. He went across the street to Old Phoenix National Bank at the time, and he deposited money there every month. And then he testified that he would accumulate bank receipts and then send them to Mrs. Turner to show those deposits periodically. He also testified that he used his own funds to pay the rent for the upstairs museum. He provided no physical evidence that rent was ever paid by Elyria Arts, Inc. or the nonprofit. But it's our position that even if Mr. Ormandy used the funds from these entities, he never notified Mrs. Turner of the source of those funds, or the source of the funds that changed from him individually to some other party. And there's no evidence that Mrs. Turner agreed to lease any part of the property or the premises to Elyria Arts, Inc. or the nonprofit.
So Mrs. Turner, counsel, lived out of town.
She lived in, correct. She lives in Tennessee. She's in her 90s now.
Was she aware that two of the units were occupied by Elyria and the toy store?
No, Your Honor. The evidence provides that Mr. Ormandy was the tenant. He was using it for a toy store and a museum. There's no indication or agreement that there was separate entities that were renting from Mrs. Turner. To have a specific enforceable contract between Mrs. Turner and those entities, you'd actually have to have either an oral or a written lease agreement, which would specify those terms, the identity of the parties, the subject matter, the rent, and so forth. But the only evidence is that this was an oral month-to-month lease agreement between Mr. Turner or Mrs. Turner and Mr. Ormandy. At most, it's our position that Elyria Arts, Inc. and the Train Museum were sublessees unbeknownst to Mrs. Turner. And it is clear in Ohio law that there's no privity of contract between the original landlord and a subtenant, and the rights of its subtenant to possession would terminate upon the termination of the rights of the original tenant. So when Mrs. Turner terminated Mr. Ormandy's month-to-month tenancy, any rights of possession held by Elyria Arts, Inc. or the Train Museum, the nonprofit, were terminated as well. Accordingly, the manifest weight of the evidence supported the trial court's finding that the only landlord-tenant relationship that existed here as a matter of law was between Mrs. Turner and Mr. Ormandy individually. And by her serving the notices on Mr. Ormandy and filing the complaint, she filed a complaint against Mr. Ormandy, then it satisfied the jurisdictional steps for the eviction. Moving on to appellant's issue number 4, which has to do with the he feels that there was inadmissible evidence regarding Mr. Ormandy's romantic relationship with Mrs. Turner. Mr. Ormandy fails to identify in any way how this evidence was unfairly prejudicial to him. Rather, it's our position that the evidence provided a context about the party's business relationship and the circumstances surrounding his tenancy. It also shed light on the fact that Mr. Ormandy, his veracity was at issue at trial, and he certainly had efforts to take advantage of Mrs. Turner. Of course, the trial court has broad discretion to enter evidence, and it would only be excluded under evidence rule 403, and that would be reversed only upon abuse of discretion of the trial court. Our position is the evidence proved that Mr. Ormandy and Mrs. Turner were romantically involved, that he was married at the time to another woman, and he encouraged her, Mrs. Turner, to purchase this property in 1991 so he could operate a toy and train store. He testified that he didn't have money at the time to purchase the building. The evidence also showed that Mr. Turner was taking advantage of that relationship by not paying a fair market rate for the subject premises. He was paying the same rate of $1,270 a month since the mid-2000s. And Mrs. Turner before was receiving $1,775 a month, a total combined amount of rent from prior tenants for the space. And the evidence that was presented at court showed that she lost nearly $100,000 in rental income by renting to him. Evidence also showed that Mr. Ormandy misrepresented the value of the property when he wanted to purchase it. He told Mrs. Turner that the subject premises was worth $200,000 when the evidence showed there was an appraisal that the building was worth $300,000. As I indicated before, Judge Teodosio, Judge Teodosio, Mrs. Turner is a Tennessee resident. She was not present in Medina County at the time. She was in her 90s or in her 90s now. And she had no way to confirm Mr. Ormandy's representations about the property. So it came out also that Mr. Ormandy misrepresented that the businesses on Medina's public square were failing. Mrs. Turner's daughter testified at trial that she traveled to Medina and viewed the square after he represented that to her mother. And every storefront was filled, every parking lot was filled, and there were no properties open for rent. So it's our position that this evidence did not confuse or mislead the trial court, but it illustrates that Mr. Ormandy was merely positioning himself to purchase the property for a bargain price and capitalize on that romantic relationship. So the trial court did not abuse its discretion when it admitted this evidence, but overall, Mr. Ormandy has not shown how that would be unduly prejudicial to him. In conclusion, it's undisputed that Mrs. Turner satisfied the notice provisions of Revised Code 1923-04. She served Mr. Ormandy with a notice of termination of month-to-month tenancy. It was served on November 24th. It was effective December 31st, 2020. And then she subsequently served Mr. Ormandy with a 3-day notice to leave premises on January 6th of 2021. He failed to vacate and he continues to occupy the entire premises. She filed her eviction complaint on January 20th, 2021, nearly 1 year ago. Accordingly, the manifest weight of the evidence supported the trial court's finding. The only landlord-tenant relationship that existed was between Mrs. Turner and Mr. Ormandy, and she was not required to serve Elyria Arts, Inc. or the nonprofit Train Museum with an eviction notice or name in the complaint. By serving him with the notices and naming him in the eviction, she satisfied the statutory jurisdictional steps to proceed with the eviction. Accordingly, the trial court's entry granting possession was proper and should be upheld. Mr. Ormandy's assignment of error should be overruled. Thank you.
Thank you, Attorney Larrabee. Let me just check. Judge Callahan, do you have any questions before we move on? What about you, Judge Carr?
No, thank
All
you.
right, thank you very much.
Thank you.
Attorney Oberholzer, you will have your full 5 minutes for rebuttal.
Yes, thank you very much, Your Honor. I believe I unmuted myself correctly.
We can hear you. Yeah,
Okay,
we can hear you.
Thank you very much. The arguments that the counsel has put forth indicate that John Ormandy, for whatever he is, obviously is personally not entitled to possession, if in fact he ever personally had possession. I don't know that I need to argue much in rebuttal except for one thing. If you're going to serve John Ormandy DBA and you name 2 corporations in that DBA, why, if nothing else, wouldn't you have made the people that you serve the notice on the party as party defendant? They didn't do that. They just made John Ormandy as a party defendant. They did not name the 2 corporations that were in that property. Whether they did it for tax purposes or whatever they did it for, we would argue is irrelevant. We would argue that a lot of this is irrelevant. The question is, does the Medina Train Museum and does Elyria Arts have a right to be at the table to argue about whether or not they have the ability and the legal right to be in possession of space at this property? They were never given that opportunity. So we have all this argument that's been made, and it sounds very wonderful, but the people that are affected by that argument, the museum and the corporation, weren't present, weren't joined. And the rule says they should be. So when it comes right down to this, if this is what the rule says and the rule wasn't followed, we would argue that that's error and they should have been made party. This business about all of this romantic relationship, how do you know it's prejudicial? It's allowed in, even though there was an objection. What effect did it have on the trier of fact? That's impossible to tell. I mean, you're not in the trier's mind, but in any extent, we would argue that if you're going to serve a 3-day notice on 2 corporations and you're arguing about possession, then those corporations certainly have a right under the rule to be served, and they were not. Thank you very much.
Thank you both for your presentations today. On behalf of Judge Callahan and Judge Carr, I want to let you know that we do appreciate your appearance by video this morning. Of course, we're going to take this matter under advisement. We'll issue a written decision, which will be mailed to both of you. And the decision is also posted on the Ohio Supreme Court website. Again, thank you for your arguments. The court's going to be adjourned until Thursday, February 3rd, where we will next hear oral arguments. Counsel, have a very good day.
Thank you.
Thank
Have
you
a good
very
day.
much.
Bye-bye.
Bye now.